Well, good evening, everyone. I'm Bill Traynor, the Dean of Georgetown Law, and it's a great pleasure to welcome you all here, and it's a particular honor for us to welcome back to Georgetown Law Justice Ginsburg. Round of applause. So the Justice will be joining us in a minute, and so it's not a bait and switch. But I have to say, it's great to see you all here. When we were initially planning this event, we were originally going to have it in a much smaller venue because it's July. Students are gone, faculty mostly not around. So we figured we wouldn't attract a large audience. We didn't have to worry about that, it turns out. The Justice obviously has serious star power. So we, as soon as the event was set out to the Law Center community, we got enormous number of RSVPs. We had to shut down the RSVP link within 24 hours. We have a satellite venue. Please come on in. With our first panel, Ruthanne Deutsch, Dori Bernstein, and Justice Ginsburg.
Thank you so much, but sit down.
So you're about to be treated to an extraordinary program that will focus on Justice Ginsburg's legacy of gender equality in life and in the law. Our first panel, you'll hear a conversation between the Justice and two of her former law clerks, Ruthanne Deutsch on the right and Dori Bernstein. And they will be in conversation with the Justice about her own life, as well as the current state and future direction of the law on gender equality. Then, following the interview, Joan Biskupik, the CNN correspondent and Supreme Court biographer, will moderate a discussion of these issues with her stellar group of women, including Judge Nina Pillard of the United States Court of Appeals for the D.C. Circuit, Professor Katie Gibson, a professor of rhetorical studies at Colorado State University, and author of a book about Justice Ginsburg's legacy of dissent, Fatima Goss-Graves, the president and CEO of the National Women's Law Center, and the woman who did so much to put this event together, Elizabeth Weiger, president of the Constitutional Accountability Center. So a round of applause. And after the conversation, everyone is invited to reception at a program in the Hotong Sport and Fitness Lobby. So welcome. And before I turn matters over to the first panel, as Dean, I just have to point out the influence of Georgetown Law on nearly all of tonight's speakers. That's my job. Sorry about that. But Ruthanne and Joan both have their JDs from Georgetown. And Ruthanne, Elizabeth, and Dori are former fellows in our appellate litigation clinic. Dori has served for 9 years as director of the Supreme Court Institute and recently won our teaching award. Shout out to that. Judge Pillard taught here for many years before ascending to the bench, and she now teaches a seminar on federal practice, which we're delighted about. And Justice Ginsburg's husband, Marty, was, of course, a beloved tax professor here for many years. And we have a Martin Ginsburg tax professorship. And we are deeply honored by Justice Ginsburg's ties to our community. We have a lecture series in her honor. She has been a frequent speaker at the Law Center, including speaking on many occasions to our first-year class and to our graduating class. And I have to say, just kind of walking out here, seeing all of you, one of the questions I'm often asked is, what's my favorite moment as Dean of Georgetown Law? And it's a moment very similar to what we all just experienced. It's walking through that door when Justice Ginsburg is about to speak to the first-year class. And as she walks through the door and the room is packed, and looking out at the sea of faces, many of the first-year students wearing notorious RBG t-shirts, and seeing the excitement and the admiration on all of our students' faces. And every time it happens, I always think, what more inspiring way to start a legal career than to have the opportunity to hear from the justice. And that's the opportunity we're now all about to have. So welcome all, and welcome back. Thank you, Justice Ginsburg.
Thank you, Dean Traynor. And Justice Ginsburg, thank you so much for being here with us today and taking the time to talk. We're very grateful. And our first set of questions is going to cover how gender equality manifests in your own life. And Dori is going to start the ball rolling.
So you and Marty enjoyed a remarkable partnership, really a model of mutual support and shared responsibility. Safe to say your marriage was unusual, even in today's standards, and virtually unheard of in a prior generation. So here's what we all want to know. What's your secret?
No secret, Dori. It was luck that I met Marty at a time when the best degree that a girl could have was not her BA or her JD, it was her MRS. Marty was a most unusual fellow. I've said many times he was the only boy I ever knew up till that time who cared that I had a brain. And we met under the best circumstances. Marty had a girlfriend at Smith College, and I had a boyfriend at Columbia Law School.
This is interesting.
And our friends thought it was a long, cold winter in Ithaca. So we were, for 2 years, just the best of friends. If ever I wanted to go to the movies, I'd call Marty. Or we often went to the college spa together just to talk about anything and everything. But the thing about Marty was that he had such confidence in himself. He was very comfortable with who he was. And he never regarded me as any kind of a threat. On the contrary, Marty thought that I must be really special if he wanted to spend his life with me.
So no self-esteem issues there.
Mm-hmm. He was always my biggest booster.
So did you negotiate divisions of labor at home and around the family?
There were no negotiations, but we just did what needed to be done, and at different times. I carried the laboring oar at home. Marty was determined to become a partner in his law firm in 5 years, which he did.
Wow.
So during those years, I did most of the child care, and that continued until he did make a partner. And then it switched when the women's movement came alive at the end of the 60s. And Marty realized that what I was doing was very important. So he took on more of the homework than he had before. I was, to tell the truth, phased out of the kitchen at an earlier time by my food-loving daughter.
So did he teach himself to cook, or did somebody?
Well, Marty, the way he tells it, he said 2 women are responsible for his skill in the kitchen. One was his mother, and the other was his wife. And he gave his mother a bum rap. She really was quite good. He was altogether right about me. But our arrangement was that Marty would do the weekend cooking and the company cooking. He never let me cook for a guest. Then when Jane was starting high school, she noticed the enormous difference between Daddy's cooking and Mommy's.
Really?
And she decided that I should be phased out of the kitchen. And for me, it was like Tom Sawyer and the Fence.
Brilliant. So it sounds like you were able to make compromises so each of you could advance your own professional goals. And sometimes he would take a back seat on his career, and sometimes you would do that.
Yes, and sometimes fate made the decision for us. I had had an operation just before I started law school. So then we switched. Who was doing the heavier work at home? Marty was. This is the cleaning and home care. Marty had an idea about child rearing. I don't know where he read it, but he had the notion that a child's personality is formed during her first year of life. So he wanted to spend as much time caring for Jane as he could.
Do you think that was right?
Do I think his theory about the first
Yes.
year? In part. In part.
So can you talk a little bit about Marty's own family background? Was his parents' marriage a more traditional gender role arrangement, or were they also more equal in terms of sharing responsibilities?
And they were traditional in the sense that Marty's father had a good job. He was a vice president of Montgomery Ward. And his mother, I wouldn't call her a homebody because she was a great athlete and a wonderful golfer. So she spent most of her time on the golf course.
So were they supportive of your goals and your choices?
Well, if you think Marty was extraordinary, his parents were more so. I've told many times the advice that I got from my mother-in-law the day I was married in the home where Marty grew up. And Mother took me aside and said, "Dear, I'd like to tell you the secret of a happy marriage."
Oh, she knew.
I'd love to hear it. Yeah. So it was sometimes it helps to be a little deaf. And that was excellent advice for the 2 law faculties on which I serve, DC Circuit, and even today at the Supreme Court. But Father was remarkable. Marty was called into service after his first year of law school, the year I graduated from college. And I became pregnant that first year we spent in Fort Sill, Oklahoma. I was really worried about how could I manage Harvard Law School with an infant. And Father's advice was, well, Ruth, if you don't want to go to law school, no one will think the less of you. But if you really want to go to law school, you will pick yourself up, you will stop feeling sorry for yourself, you will find a way. And that advice, do I really want this enough? And if I do, I will find a way.
Well, speaking about support, a supportive boss is very important for women who recognizes that parenthood requires flexibility, and that for women to achieve their goals professionally, they need a boss who understands that. And we were both moms when we clerked for you, and we can attest that you walk the walk for sure, and are very grateful for the flexibility that you gave us that allowed us to do our jobs but also be moms. So my question is, What was it like for you in the workforce, balancing work and family, and what were the challenges that you faced when you first started working after law school?
Well, first, let me ask you, how old were your boys when you clerked for me?
Well, Nico turned 10 12 years ago. He was 10 years old this day when I started my clerkship, and Benji was 2 years younger, so 8 years old, 8 and 10. And Dori, you were pregnant during your clerkship.
Well, Louisa was 2, no, by the time I clerked, Louisa was 3, and then I got pregnant with Isabel during the clerkship.
And Isabel, that was a tough time.
Yeah.
I
Not a happy pregnancy. Nice kid, but.
Dori, you were first a staff attorney at the D.C.
That's
circuit, and I was getting these memos. They were just outstanding, head and shoulders above the rest. And so, who is this woman? And I'd like her to be my law clerk. So you came the next year, and there was a point in your pregnancy when you were just confined to, you had to be flat on your back for, I don't know, it was many weeks.
It was about 4 weeks. I was first hospitalized, and then when I moved home, I was up in the attic because I had to be as far as possible from any smell of food because I just couldn't keep anything down. But you were great. You called while I was home. You would call periodically and catch me up on what was happening in chambers. And luckily, I was able to come back when we started sitting again in January after the holidays. And you treated me just like the guy law clerks.
Yeah.
And your co-clerks were pretty good.
Yes, they were lovely.
We were all rooting for you. We knew how hard it was, what you were going through. But I should say, the first law clerk I had who had childcare responsibilities was not a woman. It was David Post. Mm-hmm. David had gone to Georgetown at night, and his clerkship application said, well, I'm going to school at night because my wife is an economist. It was either the World Bank or the International Monetary Fund, I don't know.
Sure, American Development Bank, yeah.
And so I take care of the kids during the day, take them to the soccer practice. And so that was David Post. I will admit that there was one other aspect to his application that made him irresistible. Most law clerk applicants give us their writing sample, their moot court brief, or their law review note. David Post gave me a paper. It was his first year, in his first year writing a seminar. They were to write an essay, and his was on the law of contract as played out in Wagner's Ring Cycle.
Oh, God.
Couldn't have written a more perfect piece.
Did you even bother reading it, or was the title?
But I remember that first year, we didn't have the internet yet. There was Lexis and Westlaw, and I went to the chief and said, I have a law clerk who needs a flexible schedule. So can he have Lexis and Westlaw access at home? Absolutely not. The clerks are expected to be on the premises. Mm-hmm. The next year after that, every clerk had access at home to Lexis and Westlaw. So my own experience, well, when my daughter was born long, long ago in 1955, I was one of very few working moms in the class. And Jane thinks she was the beneficiary of that because she kept getting invited for sleepovers and weekends, skiing weekends. She said that the parents of her classmates felt sorry for her because, and Jane's idea is the less she saw of me, the better. Anyway, 10 years later, and this is an example of what changed in society, And my son is born, and he's going to school, and it's not at all unusual to have 2 earner families by then. But still, the woman was expected to take care of the children's inoculations, their new shoes, their medical checkups. And my son, who today is a very fine human, was what I call a lively child and what the school called hyperactive. And I would get calls at least once a month. Please come down to see me, meet with the room teacher or the school psychologist or the headmaster. We need to tell you about your son's latest escapade. So one day when I was really weary, I'd stayed up all night writing a brief. I said, this child has 2 parents. Please alternate calls. and this time it's his father's turn. So they did call Marty at his law firm, and he came to the school. And he was told James's latest infraction. And what was it? Your child stole the elevator. Well, it was one of those handheld elevators, and a classmate of my son's had dared him to take the kindergarten class from the ground floor to the top floor. He did.
How old was he?
He was in the 5th grade.
So 10.
So,
That's impressive.
so Marty's response to this
Yes.
terrible thing that my son had done, he said, so he stole the elevator. How far could he take it? Now, I don't know whether it was Marty's wonderful sense of humor or their reluctance to take a man away from his work. But after the elevator incident, the calls came barely once a semester. They were much more reluctant to take a man away from his work than a woman.
So following up on that, besides presenting a united front to schools, pediatricians, the like, do you have any advice for working families today with 2 earners that are struggling to balance the demands of a career and the family responsibilities?
For me, the 2 parts of my life, each was a respite from the other. I mean, starting when I was in law school, we had a nanny who came at 8 and left at 4. So I was, in my time at law school, I wasn't wasting a minute. I was reading, studying, outlining all the time. But when it came close to 4 o'clock, that was it. I closed the books, went home, played with Jane, went to the park with her. And then after she was fed and went to sleep, I went back to the books. But having that contrast,
Right.
it was. By the time she went to sleep, I had enough of child, and glad to go back to the books. Also realizing that so many men wake up one day and their child has grown and they've had very little to do with raising that child, and they regret it. The years that you will spend after your child has left the nest are much longer. And if you've lost out on the opportunity to be part of the child raising, to form a bond with your child, you're really missing something important in life.
Very true. And I had a similar, I used to leave here at 4. My kids were 2 and 4 when I started, and I would pick up a snack in the vending machine in the cafeteria and run to get them at daycare. And while I was here, and while I was with them, I was with them. So my next question is about moving from domesticity to foreign travels. We know you went back to Sweden earlier this year, retracing your steps. And we know that when you were there the first time, you learned an awful lot about civil procedure, Swedish civil procedure, producing a master work on the subject. But we're not going to ask you about that today. What we'd like to know is, what did you learn about gender equality in your visits to Sweden? And in particular, if anything, the role of the courts there.
First, let me correct one thing that you said. It wasn't a masterwork. No, it's true. It was the very best book ever written in English on Swedish civil procedure, and it was also the very worst because it was the only. So.
Masterwork for English readers. Yeah.
So, you want to know what surprised me about Swedish society, or
what were your takeaways in terms of gender equality there, compared to your experience in the United States, and you know, what were the differences?
This goes back to 62 and 63. Women were perhaps 5% of the law students in the country, in our country. They were 20% in Sweden. Sweden, as most civil law countries, had a career judiciary. So soon after law school, you decide, do you want to be an advocate? And then you train to be a practicing lawyer. Do you want to be a judge? You take an exam. If you do well enough, you go through an apprenticeship, similar to a clerkship, and then you go up the ladder in this judicial career. So at that time, there were many women, judges and prosecutors. There were very few women in the practicing bar. But I watched one proceeding. It was a trial court in Stockholm, and the presiding judge is 8 months pregnant. This is at a time in the United States when if you were a teacher and you began to show, you were out. Right. You were out of the classroom. There was another experience that same summer. A woman named Sherry Finkbein from Arizona had taken thalidomide. And she wanted to have an abortion, which she could not get in her home state. So she came to Sweden. And that was a big story in the press. Then there was a woman who was writing a column. Her name was Eva Moberg. And the column was to this effect: why should the woman have 2 jobs and the man only one? And what she meant was it was accepted, it was thought right and proper for there to be 2 incomes in the family. But the woman was expected to have dinner at the table at 7, take the children for their medical checkups and the rest. There were many conversations. Some women, that I call the queen bee type, said, I don't need him to share in anything. I can do it all. You know, I'm a doctor and I have a flourishing practice, but his slippers are at his armchair when he comes home. And there were others who said he should do a lot more than take out the garbage. So that was revealing. That was I didn't do anything with it immediately because there was nothing to be done in the United States. But it was sort of on a back burner, and then when the women's movement came alive in the late 60s, I was just exhilarated with the opportunity that finally the time was right to make a change. It should have happened long before.
Well, that sort of segues into another question, which is the road not taken. Because you've said before that if you had actually been hired by a law firm right out of school, you'd probably have spent your career as a law firm lawyer. And I wonder whether you would have actually found that very satisfying, or just being a commercial litigator, or whether you actually sort of lucked out that you didn't get a job at a law firm.
Well, I certainly lucked out, and Justice O'Connor would tell the same story. She was at the top of her class at Stanford Law School. No one would hire her as a lawyer. So what did she do? She went to a county attorney and she said, I'll work without pay for 4 months, and then if you think I'm worth it, you can put me on the payroll. How I got my first job was I had a professor at Columbia Law School who was in charge of clerkships for Columbia students, and he was determined to get me a job. He called every district judge in the Southern District of New York, every judge of the Second Circuit, and most of them said, well, even if we were ready to consider a woman, she's a mother, and that's just too much. But this great professor, Jerry Gunther, picked a district judge who was a Columbia undergraduate and law school graduate, always took his clerks from Columbia Law School. So Jerry had a carrot. He said, give her a chance, and if she doesn't work out, there's a young man, highly qualified, who's going to a downtown firm, and he'll come in and take over. So that was the carrot. There was a stick. The stick was, if you don't give her a chance, I will never recommend another Columbia student to you. So that's how I never knew this till years later when Jerry told me about it. I assumed because the judge had two daughters that he was thinking about what the world would be like for them.
So you gave him the benefit of the doubt, even if he didn't deserve it.
But then after, that's what it was like for women of my vintage. Getting that first job was powerfully hard. But if you got that job, you did it usually at least as well as the men. So the second job was not the same hurdle. So when I finished my clerkship, I could have gone to any number of law firms. The story that Justice O'Connor tells about her experience, and she said this to me, well, think of what our lives would have been if there had been no discrimination. What would we be? We'd be today retired partners from some large law firm. But because we didn't have that route to travel, we had to find another way.
So I think we want to transition to some less personal questions and more legal questions. Oh, all right.
And she doesn't want to ask it, so I will ask it. It's a silly question, but we know that you studied with Vladimir Nabokov in Cornell, and we know how much you love words. And did you ever consider writing fiction?
Never, because I don't have the talent to do that.
Wow.
But Nabokov was a major influence on the way I read and the way I write. He was a magnificent teacher.
Very lucky. Well, whatever the road's not taken, one thing is very lucky for all of us, that you took the road you did. So thank you. Now we will move to a few questions about the law, moving away from your life, and Dori's going to lead us off again.
So this year we're celebrating the centennial of the 19th Amendment, which enabled women to vote. And in the last election cycle, we elected 117 women to Congress, which is a new record. Woohoo. But so we're making progress, which is great, but women have not come close to political parity in this country. We hold just a quarter of the seats in the House and in the Senate, and of course, only a third of the Supreme Court. And we have yet to elect a woman as president. So over the last 50 years, the federal courts have been instrumental in accelerating our progress, thanks in no small part to your efforts. But looking ahead to the next 50 years, what do you see as the work remaining to be done?
When I go back to what you said about impressive numbers, but not enough, that's right. There is a very important first on the Supreme Court this term. And it's thanks to our new Justice, Justice Kavanaugh, whose entire staff, are all women, all of his law clerks are women. And with his 4 women as law clerks, it's the first time in the history of the United States that there have been more women clerking at the court than men. So what do I see? Well, first I should say what we were doing in the 70s. We were getting rid of all the overt, the explicit gender-based classifications. There was nothing subtle about it. It was women can't do this and they can't do that. Almost all of those explicit barriers are gone. What remains is what's often been called unconscious bias. And a vivid example of that, my best example, is the symphony orchestra. When I was growing up, you never saw a woman in the orchestra except perhaps the harpist. Howard Taubman, a famous music critic for the New York Times, swore that he could tell the difference between a woman playing the piano and a man, a woman playing the violin and a man. Somebody had the bright idea, let's put him to the test. Let's blindfold him and see how he does. Well, he was all mixed up. He was certain that it was a woman when it was a man, and the other way around. So he admitted that brought home to him. And he saw a woman, he had certain expectations for her, and he rated her that way. After that experiment, they came up with the bright idea, let's drop a curtain between the people who are auditioning and the people who are conducting the audition. So they won't know if it's a woman or a man. With that simple change, there was an almost overnight shift in people who were showing up in symphony orchestras. So I was telling this story at a music festival some years ago, and a young violinist came up to me and said, "You left out something." What did I leave out? "You left out that we audition shoeless, so they won't hear a woman's heels coming on the stage." Sadly, we can't duplicate the drop curtain.
In electoral politics.
But one of my best examples of the way unconscious bias operated was a lawsuit, it was about 1978-79, against AT&T for not promoting women to middle management jobs. The women did about as well as the men, up to the very last test, which was called the total person test. And that was an interviewer sitting down and having a conversation with the candidate for promotion. It was at that point that women dropped out disproportionately. And why was that? Because the interviewer had a comfort level facing someone who looked just like the interviewer. But if the person being interviewed was of a different race, of a different gender, there was a discomfort experienced by the interviewer. He didn't quite know what makes this person tick. So he's feeling uncomfortable, and it ends up in a lower rating for the woman, not consciously to discriminate. It's that's hard to get through. There was a case before the European Court of Justice. The European Court of Justice is the highest court for the European Union. And it was a province in Germany that said, for civil service jobs in fields that have been mainly occupied by men, if two candidates are about equal in qualification, prefer the woman. And there was an argument that was reverse discrimination, not compatible with the equality norm of the Rome Treaty. But if you read the decision carefully, you can see between the lines the court is understanding that this is not necessarily a preference for a woman. Giving her a plus is a way of overcoming the unconscious bias that would operate in favor of the man. So that, I would say, for women employed today outside the home, unconscious bias is there, and what you talked about before, the work-life balance.
But I'd be interested to know whether you think the federal courts would play as central a role going forward, because what you just described that was accepted by the European court would not be accepted by the courts here.
But there is a statute that is premised on the working woman, and that's the Family Medical and Leave Act, which the court, thank goodness, upheld in an opinion, excellent opinion, by the old chief, and brilliantly argued by now Judge Pillard.
This past term, litigants in a number of cases urged the court to revisit prior holdings in a variety of contexts with mixed success. And in your view, I'd like to know, do you think public perception of the court's legitimacy should be considered in adhering to precedent?
Whether the court should consider its place in the system?
Yes.
I think all of us do. And no matter where we are on the political spectrum, the one thing that each of us feels deeply is we want to leave that institution in as good a shape as we found it. We do not want to do anything to tarnish the court's reputation, because it is unique in the world. Until after World War II, most countries didn't have anything like judicial review for constitutionality. Parliament spoke the last word about what the law was. It wasn't until after World War II that constitutional courts emerged in Europe and other places. The horror that existed in Germany persuaded many people to think that popularly elected legislatures can't always be trusted to keep the society in tune with basic, fundamental human rights. So maybe having a constitutional court would be one check against return to an autocratic government. So then we saw constitutional courts growing. The idea of having a court with that authority became popular, but for many, many decades, the United States was just about alone in the world in having a constitution that was not just aspirational, but law on the ground, law to be observed here and now, law that trumped any lesser law.
Thanks. So one last question before our fabulous panel takes the stage, and it's about cases. And we know you've said in the past that you won't tell us what is your favorite decision that you've authored yourself, because that's like picking a favorite child. But
Grandchild.
or grandchild, yes, even harder. But what about a favorite decision written by another justice, and in specific a favorite decision or two about the 14th Amendment and gender, because that's what we're going to be talking about with the panel.
This gives me an opportunity to say something about the 14th Amendment, because most of the litigation in which I was involved was against the federal government. And where is an equal protection clause in our Constitution operating against the federal government? The 14th Amendment says, nor shall any state deny to any person equal protection of the laws. It wasn't in the Fifth Amendment for a good reason, because when the Constitution was new, the Constitution acknowledged and permitted slavery. So this question of does the Congress has to abide by an equal protection norm came to a head in the series of cases that were combined to make Brown against Board. And one of them involved D.C. public schools. Well, D.C. is controlled by the federal government, so it wasn't a state. There was no 14th Amendment. So that's when there was kind of a reverse incorporation. And the court said that the Fifth Amendment due process clause essentially incorporates the explicit equal protection guarantee that's in the 14th Amendment. I mean, they had to do it. Could you imagine a Supreme Court saying states can no longer have law-enforced segregation in schools, but District of Columbia can? It would be unthinkable. So anyway, what was the question?
Your favorite decision about gender equality written by somebody other than yourself.
Well, you mentioned Nevada against Hibbs, the Family Medical Leave Act case, but there was a case at the end of Justice O'Connor's very first term on the court. It was Mississippi University for Women against Hogan. Hogan was a man who wanted to go to nursing school, and the best nursing school in the area was the Mississippi University for Women, but they wouldn't accept him. And Justice O'Connor wrote an opinion for the court saying, you cannot deny to either men or to women an educational opportunity simply because they are female or male. So that case was in, 1982. Then in 1996, the court was confronted with the Virginia Military Institute case. And this time it was women wanting access to an educational facility up till then reserved to men. The principal precedent for the Virginia Military Institute case was Justice O'Connor's opinion. And that's another case where you could read between the lines. So Justice Powell, who was on the other side, saw the Mississippi University for Women as a kind of affirmative action for women, something reserved just for them. But Sandra, having had experience in life, knew that the best way to upgrade pay in a field that was dominantly for women is to get men to do that job. So she didn't see Mississippi University for Women excluding men from the nursing program as any kind of affirmative action. Quite the contrary. So that was that Mississippi. In fact, when I brought it home and showed it to Marty, and he read Justice O'Connor's opinion. He said, "Ruth, did you write this?"
Later. And any thoughts to share on a least favorite? Any thoughts to share on a least favorite?
There have been 2 series of cases where the court got it quite wrong. It was question of acquiring citizenship through a parent. And the law is there. I said almost all the explicit gender-based classifications were gone. But in the immigration area, immigration and naturalization, this distinction remained. The parents are not married. Child born abroad. If the mother is a U.S. citizen, the child automatically acquires the mother's citizenship. But if the mother is the alien and the father is the citizen, the child does not.
Unless they're married.
Yes. So that was just one more example of was this a favor to women? No, saying that if the child is born out of wedlock, he's fancy-free. He has nothing to do with the child, no responsibility for it. But she's saddled with it. She can't get rid of it. It's her burden. So I didn't see this, as some of my colleagues did, as something operating benignly in women's favor.
And then you said there was another one?
Well, there were two in a row.
2 in the same
Yeah.
the same line.
But it would be hard for people of a certain age. When I think of a colleague I revere, John Paul Stevens, he had been in the Navy in World War II. And there were a lot of Madame Butterfly stories that time. And I guess he didn't conceive of his buddies, no matter how many children they sired, as having any kind of bond and being financially responsible for them. So it's hard to break through that particular mindset. So I agreed with Justice Stevens in most cases, but in these cases we had a very strong disagreement.
Well, thank you so much, Justice. This has been such a lovely conversation and really a treat, and we all really appreciate your coming here, especially just a handful of days after the end of a term. I cannot believe how fantastic you look, given that you've just been through the end of another term. So now Ruthanne will escort you off the stage. What?
A gift.
And so, and I will call the panel up to do the second part of our program.
Thank you.
But wait, there's more. So we are privileged to hear from a panel of highly accomplished lawyers who bring a variety of perspectives on gender equality and Justice Ginsburg's work. After the discussion, we hope everyone will join us for a reception in the Hotung lobby just across the campus. I'd like to introduce our moderator, Joan Biskupik, She's a full-time CNN legal analyst who's covered the Supreme Court for 25 years and has written several books on the judiciary. She's published biographies of Scalia, O'Connor, Sotomayor, and most recently, Chief Justice John Roberts. A graduate of, as you've already heard, Georgetown University Law School. Joan was a finalist for the Pulitzer Prize in Explanatory Journalism in 2015. Thank you, Joan.
Okay, thank you. Thanks to all of you for being here and for staying here. We appreciate it. I think you know just about everyone on the panel, but just to refresh your memory, to my far right is Judge Nina Pillard of the DC Circuit. Then Katie Gibson, a professor of rhetorical studies at Colorado State, who's also written a book on the legacy of Justice Ginsburg's dissent and her feminist rhetoric in the law. And to my immediate left is Elizabeth Wydra, the president of the Constitutional Accountability Center. And she was the woman who thought of this idea with Justice Ginsburg. So that's why we're all here. And then to my far left, Fatima Goss-Graves, who's president and CEO of the National Women's Law Center. We're going to We are going to cover a lot of ground in Justice Ginsburg's life and her legal legacy. But first, we really want to take advantage of what we just heard. And all of us have probably seen Justice Ginsburg in action so many times. But I just want to ask each of the panelists, like, what struck you? Did you hear something new? What just jumped out? And I'm going to start with you, Judge Pillard, first. Although I know what you really want to say is the part about when she said your brilliant legal arguments in the Hibbs case. But
that's nothing new.
We will take that as judicial notice, as you say, that definitely is true. But what struck you?
So one of the things about Justice Ginsburg is, she worked for the American Civil Liberties Union Women's Rights Project, but she isn't necessarily a women's rights advocate or champion or jurist. She's really someone who stands for sex equality or gender equality. And it struck me again and again in the remarks that she made how much she thinks it's important that men have opportunities to do things that are typically associated with women and femininity, just as it's important for women to have opportunities to do things that are historically male. And I also think she has such a signature style, and we're going to hear more from Professor Gibson about her rhetorical style. But so one thing that I noticed was when Ruthanne Deutsch was telling the justice how important it was to her as a new mother to work for a boss who was flexible. She said, it's so important for women, the question was, to have someone who understands where we're coming from, and we were each new mothers. And the justice didn't take issue with that framing. But then she turned around and she said, the first clerk that I had who had parenting responsibilities was a man. And then she talked about how she tried to get him Westlaw. So she's championing him as well. So she, in this very Ginsburgian way, is sort of, accepting it, but also leaving her own mark. And then she had this really, I thought, moving statement where she said, so many men will not take as active a role in the raising of their children as they might, and then it goes really quickly, and they regret it. And again, it's a piece from her of a kind of advocacy of this is a thing of value for people, for parents. So that, for me, that was sort of so crystallizes some of her advocacy and also her worldview about gender.
Terrific points. Katie Gibson?
Yeah, and to hop on that, I think her work and her comments on gender reveals an awareness of how rigid norms of masculinity are really awful for women too. So there's like that recognition that, creating a world where is more safe for lots of different kinds of gender performances is good for everybody. I was struck by the conversation with her clerks and how much of an advocate she was for her clerks as well, or is, and just made me realize how important it is to have people with diverse life experiences in positions of power. So that's really what struck me.
Thanks. Fatima?
I think there are two things that struck me. One was the advocate for clerks and the story that she told that she noticed Dori's writing. And I had a million questions to follow about had you applied and how many women don't apply and are waiting to be seen. So anyway, I thought that was a very beautiful story. But the second thing, I was sort of hanging on to every word that she had to say about unconscious bias and thinking deeply about how our laws are really ill-equipped to address it. And the case that she raised was one example of how our laws were ill-equipped to address the unconscious bias that leads people to be less promoted and receive lower pay. The case she didn't discuss was the Dukes v. Walmart case, where that was really part of what they were trying to get at, that a overall policy of leaving it to managers to decide person by person was going to allow unconscious bias and maybe not unconscious, just on purpose bias to sneak in. And she talked in her dissent in that case. She described that so beautifully, and so just. It had me thinking about what would it look like to frame up a new set of laws and strategy to really get at the problem we're facing today. So,
Great. Well, that's a good place for us to go to as we move along. Elizabeth?
Yeah, I think, it was just really wonderful, I thought, to see these three high-powered, brilliant women on stage talking about the fullness of life and law and the way in which you make choices about life, and their careers have intersected. And gosh, what Dean Traynor said about Justice Ginsburg coming to talk to first-year students, to hear that kind of message. And, as Katie and Judge Pillard said, it's not just a choice for women, and it's not just about children. I am the new mother of a 6-month-old, so I was listening very intently to all of that. But it's also just about what do you want to get out of life. And to hear three such powerful voices talking about that openly was just really impressive. But, one thing that I was really excited to hear, certainly the unconscious bias discussion I thought was interesting. And I thought not just about the laws that could be framed, but what if we had a full Supreme Court of Justice Ginsburg's? What kind of unconscious bias jurisprudence would we get out of that? It's like heaven.
Well, I have heard her say the following so many times, and I've repeated it to many people, but I heard a little twist this time with it, and that's the great remark that she heard from her mother-in-law right as she was getting married. Dear, sometimes it pays to be deaf. I've, of course, repeated that many times, but this was the first time that I heard her remind people that she adopted that view, not just with her husband, Marty, but also with 2 different faculties as she taught, and also today at the Supreme Court, which, of course, interests me. I think everyone here knows the general outlines of Ruth Bader Ginsburg's life story, but just to remind you of a couple things as we segue first into her advocacy and then talk about her time on the bench and then connect her early years in litigation to where things are today for the equality agenda across the board. The characterization she gave this time about meeting Marty was a little bit different, I thought, because I remember her talking about being set up on a blind date. I never knew that before. They had, these significant others elsewhere, and it was very cold up in Cornell. Anyway, I found that very nice. But she, as she said many times, Marty was the first guy she dated who thought that she had a brain and was happy that she had a brain. So they both they meet at Cornell. They both then go to Harvard Law School. And she's, of course, got her daughter Jane with her at the time. And Marty falls ill, and she's also taking care of him and taking notes in his classes. And she's doing so well, nonetheless, that she makes the law review. Marty does recover from his illness and graduates before she does. So they move then to New York City for his job, and she has to transfer to Columbia, where she again makes the law review and is first in her class. But despite all that, when she graduates, she can't get a job. And the interesting tale about Gerald Gunther getting her a clerkship by sort of, saying, take her or else, I thought was terrific. But what happens then when after that clerkship, she takes a research position, and going into academia served her, just as she talked about how Sandra Day O'Connor was served by going into public service and government life. Because while she's at first Columbia and then Rutgers, she starts to study more discrimination issues. And it's in 1972 when she, with the ACLU, founds the Women's Rights Project. And what I want to start with is just her unusual strategy of finding men as plaintiffs rather than women who face discrimination, but men. And I'll just refer to one of the early cases that she won before the Supreme Court, the Weinberger versus Weisenfeld case, where the Supreme Court struck down a Social Security law that provided survivors' benefits to widows with small children, but not widowers with small children. And so I want to pause and talk about what was distinctive about that strategy, and if she took what were her inspirations there that we know about, and just why that was so different. And you're in this line of work at the National Women's Law Center, Fatima. Talk about those roots of that.
Yeah, as she was giving her commentary, I was thinking about that case and others where it wasn't just the male plaintiff that was important. It was being able to challenge the notions that were so embedded in our culture, and as she talked about so explicitly in our law, about the proper roles of men and women, both at home and at work, and the presumptions of who is a breadwinner and who is not, who's working for, pocketbook money or not. And so that case in particular is interesting because it did what I felt like she was trying to do a little bit on the stage tonight. It talked both about the harm for men who are left without the income they need, but also the harm for women who would be working in their career and not be able to continue to provide for their families upon their death in the same way that men could. So I was struck by her continued ability today to point out that in grappling on and holding on to these stereotypes, it harms both men and women. And I will tell you that strong trope about who is and who is not a breadwinner in our society is one that we have clung onto deeply, and one that shows up in how it is pay practices happen today. The data shows that that men get sort of a fatherhood bump in pay, and women get a cut in pay after having children. Sorry, Elizabeth. So it is one of those hard and difficult tropes that are both difficult to detect and difficult to defeat. And so both the cultural stories that we tell ourselves are as important, I think, continually as dismantling the explicit and not so explicit legal structures that make it hard to defeat it.
You know, I'm going to ask Katie about the rhetoric of it, but first I want to ask you, Elizabeth, picking up on what Fatima said about that kind of counterintuitive notion of trying to argue to a decision maker with a plaintiff that wouldn't be so predictable. Does that remain a good strategy in terms of equality litigation? Just pick up on that.
Yeah, I think absolutely. You know, the idea that she came to the court with a plaintiff who might be someone that the justices then, all men of course, could identify more with, you know, is really smart. As a litigator, that's a really smart strategy. And I think, you know, she drew inspiration from the civil rights movement that came before her. You know, it's the idea that you would bring the case of a graduate student before perhaps a school child, you know, that someone that, you know, the justices could identify with someone who had higher education, and that sort of idea of trying to find a place where even when you are not represented on the court, you can find some means of commonality. And I love that we're having this event on Thurgood Marshall's birthday, because in so many ways, Justice Ginsburg is an inspiration in the way that Justice Marshall is an inspiration. He was obviously an advocate and then a justice. He founded the NAACP LDF in the way that she founded the Women's Rights Project at the ACLU, and both were brilliant jurists and brilliant litigation strategists. And the way that she has talked about tonight, I love the part when she talked about the way in which there's reverse incorporation. So the equality mandate of the 14th Amendment, which came after the Civil War and applies, as she explained explicitly, to the states, transformed the entire Constitution. And so going back to the Fifth Amendment, which was passed in the 18th century, it transformed that part of the Constitution. So as our Constitution goes through its iterations of progress, the entire project, just as the entire country, is transformed.
You know, I'm reminded of the fact that Justice Ginsburg, as an advocate, had such an intellectual approach to it, but she also had to figure out how to communicate these ideas. And she has told the story about sex versus gender. And grammatically, this is sex discrimination. And I think we had talked earlier about she had an assistant or who was typing up a lot of her work and kept saying, sex, sex, sex. You keep putting sex in everything, and it could be offensive to the ear. and Justice Ginsburg, then advocate Ruth Bader Ginsburg, was convinced to start saying gender. And Katie, I know you've written about how the rhetoric of the law and how it has challenged some norms. Talk a little bit about how her advocacy challenged the language of the law and how her rhetorical perspective has kind of enriched our understanding of her litigation.
Yeah, well, I think a rhetorical perspective urges us to appreciate the discursive struggle at the heart of her early advocacy. Her equal protection jurisprudence directly confronted the rhetorical boundaries of American jurisprudence as she uprooted patriarchal scripts and challenged an entrenched genre of legal language that silenced the voices and lived experiences of American women and many others who didn't fit the mold. And so her litigation strategy is often described as incremental and clear-headed about the constraints of working within the judicial system, but beneath this measured, legal strategy is really a more sweeping discursive strategy that has boldly challenged the rhetorical landscape of the law for nearly 5 decades. This bold posture is evident in the great Sarah Grimke quote that she recited to conclude her first oral argument before the court in 1973. So standing in front of 9 male judges, she said, "I ask no favor for my sex. All I ask of our brethren is that they take their feet off our necks." Referring to the quote later, she said, "It had a certain shock quality," which is what I intended. But there's a posture of dissent that runs throughout her arguments for gender equality as she confronts the deep exclusions that live in the language of the law. She often refers to that literature class that she took from Nabokov that taught her to appreciate the power of language to paint a moving picture. And she's used this lesson throughout her career to challenge rhetorical conventions that narrow legal imagination and move the court to see the law from a broader vantage point, right? To see the feet upon our necks. Her legacy teaches us that the rhetoric of feminist jurisprudence is inherently disruptive, that discursive traditions, norms of erasure, scripts of objectivity must be confronted and challenged to create space for feminist judgment in the law. So lots of us appreciate Justice Ginsburg's voice of dissent today, but a close look at her rhetorical legacy reveals she has long articulated a sharp and strategic voice of dissent to challenge the rhetorical boundaries of the law and make way for a more inclusive constitutional community.
It's a great point. You know, even as she stood before the court and had that remark about their foot on the neck, you know, she just said it so evenly that I mean, they probably weren't sure what hit them. I was also reminded only recently of the inspiration of Pauli Murray on both Thurgood Marshall's work and her work, that, you know, it's quite a daring reference that I think she put in some of her early briefs, but it did it subtly and slyly, so nothing was ever in the face of people, which is, again, kind of goes to these comments that you made in the beginning about her demeanor and approach to a challenge that doesn't seem too outright challenging.
But also, though, if you look closely at her brief for Reed v. Reed, which she calls the turning point case, there's a lot of really strong language in that brief that I think we overlook sometimes when we focus on her careful, measured legal strategy. She quotes the Declaration of Sentiments that in the brief it says, the history of mankind is a history of repeated injuries on the part of man against woman, which is a really bold statement for the time. And so I think that there is a boldness that is there, right? If we're looking for it.
Yeah.
Also, in terms of citing lots of women's voices in this brief, she recited theories of feminism, included writings from the women's movement. I think that was a bold challenge to who matters and whose lived experiences are centered. So I see a boldness also in that too.
Yeah, no, good points. Okay, so then she gets on the DC Circuit where Judge Pillard is. And she's talked often about how much she had actually wanted to end up on the Second Circuit because she was up in New York. That's where Marty had his job. And she just couldn't get herself on the list for the Second Circuit. But she did get on the DC Circuit, which turns out to be quite the springboard, of course, for the Supreme Court. And she often will talk about the lucky stroke that happened, and it was because a judge was playing tennis, had a heart attack, Judge Leventhal, and she gets that spot in 1979. And so she gets on the court, and she's talked a lot about, Marty moves down to teach tax here at Georgetown University Law School, and they have a life here. And she, as we heard today, loves to talk about the work-life balance that occurred. And I know you do too, Judge Pillard, with all these connections, both in terms of the civil rights advocacy that preceded your appointment to the bench, and also to the fact that your husband had taught at Georgetown too, before then becoming the National Legal Director of the ACLU. So just what do you make of the way she characterizes her juggling act in the 60s and 70s, and how you think that judges today engage in the same balance, dropping balls?
So she, I was a colleague, Marty was a colleague of ours here. When I was a law professor, he was a professor here at Georgetown. And what a lovely human being. I mean, one of the things that she commented on was how confident he was, and that his confidence allowed him to be a more egalitarian parent. And she also uses the word luck when she refers to her ending up with Marty. And I have to say the same thing myself, that my husband is both my choice of him as a life partner, one of the luckiest choices I ever made, and also that his confidence really has allowed him to be very much a partner in raising the kids and, taking care of house and home and also having a fulfilling career. So, and in terms of her work on the DC Circuit, one of the things that's very different about being a Court of Appeals judge from being on the Supreme Court. In the Supreme Court, you always have the same cast of characters. Every case, it's the same panel. On the Court of Appeals, you just, you get different draw. You're gonna have two colleagues, these two, those two. And it's a very different kind of personality challenge. And she also was on the circuit at a time when the court was dominated by more conservative voices. And so I think part of her way of being as a judge really has its roots in that soil, and her ability to use a combination of her own personal credibility, her very her technical prowess, with doctrine, and her very unrevolutionary kind of affect. But also one of the things that I really admire in her opinions, some of the famous opinions that she's written for the Supreme Court that I think she developed on the DC Circuit, is her use of history. She will stop and go back, decades, centuries, and give you a history of how we got to where we are. And she did that in a really beautiful dissenting opinion in one of the early case in the sequence that she mentioned about non-marital children and inheriting their citizenship from their fathers and their mothers, and how the disadvantage was to fathers. And she says, this is seen as benign. It's seen sort of as maybe almost affirmative action for the women, that they get to convey their citizenship in a way that the men know. No. She says, not so fast. She goes back to 1790 in that opinion and talks about all this period when only men's citizenship mattered, only men's legal identity matters. And she brings you in this very erudite way up to the present. So I think it's the professor in her, it's the former DC Circuit judge in her, it's the, someone who is faithful to precedent, faithful to history, and it comes together in this kind of quiet power that is the Justice Ginsburg that we know.
Yeah, I want to follow up on that quiet power of using the history that Justice Ginsburg has, because we all, in a less quiet way, have heard Justice Scalia's claim of the originalism mantle, and he was really well known for that. But when you look at Justice Ginsburg's opinions, she is, in many ways, quite a brilliant progressive originalist. And she once said at a lecture that she counts herself as an originalist of sorts as well. And Judge Pillard's exactly right. She weaves together the text of the Constitution, which, as she mentions at the beginning, was not something that was inclusive of actually all of us on this stage, and many Americans were excluded from the promise of equality at the founding, and then it changed over time, fortunately. And she draws upon that text and the history and uses that along with precedent in a way that is extremely powerful. And I think, now with the conservative court, certainly with Justice Scalia, and as it gets even more conservative, is such a powerful voice in response to that, but in a much quieter way than we've seen. The play about Scalia is called The Originalist. I don't think there's going to be a play about Justice Ginsburg called The Originalist, but she is one in her powerful progressive way.
This is a good time to segue then to her work on the Supreme Court. And as strange as it seems today, she was not Bill Clinton's first choice, or his second choice, or his third choice back in 1993. When Byron White announced in March of 1993 that he was going to retire, the president turned first to Mario Cuomo, who hemmed and hawed and, as I said, played Hamlet on the Hudson and then said no. And then the president looked at a couple other people, and as some of you might remember, this was the era of tax problems and the Nannygate problems. But Ruth Bader Ginsburg was married to a tax lawyer, so of course her records were perfect. But it was actually Janet Reno, then Attorney General, who said, as the Clinton administration was sputtering a bit over that choice, go back to Ruth Bader Ginsburg. I don't know why you didn't think of her more seriously, but the truth was, in part because of her record, was moderate, relatively speaking, for a liberal on the D.C. circuit at the time. She was not as widely embraced, I think, by liberals as some other candidates might have been. But as we saw today, Ruth Bader Ginsburg has a way of, in a pinch, being able to really put on the charm. So Clinton decides that he will interview her. And by this point, we're in mid-June, after Byron White has announced on March 19th of 1993. And she goes to the White House to meet with the president, does her full Ginsburg thing. He immediately just says, I don't want to see, this is it. I don't want to see anyone else. And the next day goes to the Rose Garden, announces her, and fittingly for today, describes her as the Thurgood Marshall of the women's rights movement, having been given that line by Daniel Patrick Moynihan, who was one of her biggest supporters, along with Marty, in terms of getting her positioned. So here she comes on. She's approved. This is another staggering footnote from the era. She was approved 96-3. Who can imagine that today? On August 3rd, and she takes her judicial oath on August 10th, and this is another staggering thing in our highly polarized times. She happened to be the first appointee of a Democratic president in like 26 years, because the last one before that had been Thurgood Marshall under LBJ. So, it was such a different time. So in her first term, she, Justice O'Connor is still on the bench. And I thought it was so interesting how many times she referred to Justice O'Connor today. But Justice O'Connor, in that very first term, happened to write a decision in a sexual harassment case, in Harris versus forklift systems. And Justice Ginsburg added a concurring statement that underscored the unequal treatment of women in the workplace at the time. And she says, the critical issue is whether members of one sex are exposed to disadvantageous forms or conditions of employment to which members of the other sex are not exposed. And I thought maybe we'd talk about those early markers that she put down. And Fatima, why don't you pick up from there about just what we saw in the early jurisprudence before we had the breakout notorious RBG moments?
Well, it's interesting. If I could just pick up on your Justice O'Connor point, because as you were talking, I was thinking about the many sex discrimination cases that it was actually Justice O'Connor who wrote the opinion and Justice Ginsburg joined, and that's been true in the Title IX case, in the Davis versus Monroe case, which is the case that said Title IX applies to peer harassment in schools. In the Jackson versus Birmingham case was the case that said was a Title IX retaliation case. That was also a Justice O'Connor opinion. So it just, as we were talking, I was intrigued by that and wish she was here to ask about that. But I also thought it was interesting when she was pressed on her favorite decision that she did not write, that she said the Hogan case, which of course is the precursor to the VMI case. And hearing her talk about how important that was. In the Hogan decision, of course, it was a male plaintiff, and the case was, as she described, about really the integration of this all-women's nursing program. But what it meant in the VMI case, not just around integrating the military academies, which was so important, but what that case said really about our ability to look at sex classifications going forward and think about sex stereotyping generally, and And so that seed that she had there with loving the Hogan case and then being able to be the author of that core decision, which laid out the standard for how we view our claims under the Equal Protection Clause, is so important. The last thing that I think really is on my mind about this, I'm thinking about in more recent times, a case, another harassment case that involved supervisor harassment from not that long ago. And in that case, this was a dissenting opinion, Justice Ginsburg sort of told the story to sort of remind us all and remind the public about the many ways that you can experience harassment from someone who may not be your formal supervisor, that person who can take away your shift and change the nature of your day-to-day work, and that if that person is controlling your ability to do your job, that there should be the same type of vicarious liability. And the way in which in that dissent, she walks through what that is like to actually be that worker and experience that and have that harassment coming from someone who's effectively your supervisor, it, in my mind, really just opened up the problem with the majority opinion, which took a very narrow view. And in that case, like she did in the Ledbetter case, she said, this is a problem for Congress to clearly fix. Right? You got it wrong. You are failing to understand what it is like in someone's day-to-day lives. And I think that you see that as a theme in other cases where she's saying you're failing to understand what it is like to actually be in the shoes of that person who's come before us.
Right, and not know how much everybody else is being paid and suddenly discover it. You mentioned sex stereotyping, and I know, Judge Pillard, that's been in both the Hibbs case and the VMI litigation that you were involved in. What is the importance of her sex stereotyping approach? And we don't have all that much time left, but I do want to ask about the standard that she originally pushed for, strict scrutiny, to match race discrimination, and then went another route. Yeah. How do you understand that?
So one of the really central things that is the legacy of joint efforts of various justices, but really has a Ruth Bader Ginsburg signature on it, is this concept of sex stereotyping as in violation of the Equal Protection Clause. And the idea is, and what she does is she takes the idea of stereotyping, she says it doesn't have to be derogatory. It doesn't have to be, because I think in the old days, and maybe it's not like this for those of you generations later, but we used to think, a stereotype, it just had to be an insult. And if it wasn't an insult, it wasn't a stereotype. And she ends up sort of saying, no, a stereotype is an overgeneralization that's not accurate. So again and again, there are situations where, for the VMI case, this is a private military style school. The challenge to the exclusion of women from the Virginia Military Institute comes a generation after women are actually in the military academies, right? They're in West Point, they're at Colorado Springs, they're at Annapolis, but VMI is like, no, we have this distinctive adversative method and it's really appropriate for boys. And the whole school is like, it's a very, not necessarily that known nationally before the case, but a very highly endowed school, a place where you go there and your career in business and the military and politics is made. I mean, I think at the time of the case, had the highest per capita endowment of any private institute of higher education in the country. So it was really a plum thing. And, and a lot of people were just like, what woman would want to go there? It's this very, the upper class students yell at the incoming students. They, any little infraction, you're down doing push-ups. It's very much kind of boot camp, trial by fire. We break them down to build them up, and thought to be something for, to take rowdy boys and make them into civilized and upstanding men. And and yet there were women who were qualified, and there were women who wanted to go, and so she takes the idea of stereotype and really shifts it into, if there are atypical men or women, the men who want to go to the nursing school, the women who want to go to a VMI or a Citadel, we look at them individually. They have the right. They have the right to be treated as individuals and to be treated equally. And again, in VMI, she goes back and does this beautiful history of the school and how it is this idea that it's standing for the constitutionality of single-sex education is completely implausible because there's no corresponding single-sex school for women in the entire state. After the Court of Appeals finds liability, they try to create one, and she does a withering job of, pointing out how it is not providing equal opportunity for the women who want to go. So your question is about the role of stereotyping, and
That's okay. You've given. You're okay. This is good. This is great.
Okay. Oh, and I did want to link back on one great thing about this VMI case is that when it was argued in the Supreme Court, the principal deputy solicitor general argued, and this goes back to one of the points that some of the other panelists were making about her ability to connect. So the principal deputy solicitor general had a great Ginsburg-like piece of oral advocacy where he said he likened VMI's treatment, saying we're going to reserve this technique, which is designed for men, we're going to reserve it to men. And he says, well, imagine at the time when law schools are just opening to women, and they think, well, it just wouldn't really be right for women to be in the Socratic method where they're harshly questioned, to have them, have these difficult exams. We should have them in a more cooperative, more seminar-like. So we're going to have a separate law school for the women. And to me at the time, it seemed kind of hokey and simple, but the bench was rapt. They didn't interrupt at all as he spun out this example, and it really spoke to them in a way that I think, these cadets marching around in Lexington, Virginia didn't.
It was their language.
Yeah.
It was their language.
Yeah.
And that's a perfect segue to you, Katie, about how what you saw in her litigation strategy and her litigation rhetoric then emerges in her opinions in exactly the way that Judge Pillard was characterizing. Mm-hmm. What did you observe?
Well, I think just where we can see those early rhetorical commitments today, a good example actually is in the reproductive rights cases in terms of her fierce attention to language and pushing back on abstract conventions that universalize experiences. Just this term, she wrote an opinion that pushed back on Justice Thomas after he repeatedly referred to women who exercise their right to choose abortion as mothers. And Ginsburg's life's work has made her keenly aware of how the language of woman as mother has been mobilized throughout history to restrict women's rights. In the area of reproductive rights, also her voice of dissent has proved especially committed to challenging these abstract language conventions that universalize the experiences of women and flatten their differences. In her dissenting opinion in Gonzalez v. Carhart, she reminded the court nearly 11,000 women are severely assaulted every day in the United States, and unnecessary restrictions on abortion place these women in great harm. Her commitment to context and difference can also be seen in her Hobby Lobby dissent, as she admonished the majority and emphasized that the cost of an IUD is out of reach for many women. It's an entire month's pay for those making minimum wage. So I think we see those things, those early pieces of her advocacy in those ways, in really profound ways.
Yeah, it's amazing. We just had Exhibit A in terms of what you were just talking about, the back and forth between Justices Ginsburg and Thomas.
Yes, and I think what her efforts to foreground different voices and different lived experiences is really one of the great feminist promises of her rhetorical legacy.
In the time, I was going to turn to you, Elizabeth, in terms of the Shelby County dissent and other dissents that, first of all, as some of you know, it wasn't until 2013 that the notorious RBG meme was even created. And it was when her dissent in the Shelby County case just electrified the internet. And I think with the time we've got left, maybe if you would start us off making the segueing from, what she's done for women's rights to a broader group of civil rights issues that were probably there all along. It's just that now it's more evident with her as the senior liberal on the bench.
Yeah, absolutely. I think that, when Katie talks about the way in which she uses language to bring out kind of, I would say reality, lived experience, as Fatima was saying, and walking through the way that you experience harassment in the workplace. And one of the ways that she did that in the reproductive autonomy context is taking abortion in many ways from the jurisprudence of privacy to equal citizenship stature. And, privacy is sort of something you do in private. It's, in the dark. And by saying, hey, how can women be equal in the public square? How can we be equal in our lives if we cannot even control our own reproductive decisions, our own bodily autonomy? How can we possibly enjoy that promise of equal citizenship in the Constitution? I think that is an extremely powerful shift. And she did that also in other contexts. I think, the abortion context is probably, where she's most known for this equal citizenship stature argument. But she does it in the racial justice context as well. I think her opinions in the race-conscious admissions programs cases talk about that. The idea that it's obvious when there's a policy of inclusion versus exclusion. It's about whether or not we're trying to make real the Constitution's promise of equality that was put into those post-Civil War amendments. And in Shelby County, she, it's like the taking your foot off our neck. She just did not hold back. And she said, throwing out the pre-clearance provision of the Voting Rights Act is like, that was working so well, is like, getting rid of your umbrella because you're not getting wet in a rainstorm. And it's, the idea that she can use this language to make things real for people, even when it's something like, difficult questions of the law or pre-clearance. Yeah, that's not something that like rolls off the tongue. I mean, maybe in this room it does, but not for other people. And that equal citizenship stature idea motivates her not just in women's rights cases and gender equality cases. I think the idea that it's not just women, but it's gender. How can men be full equal citizens in racial justice context? And also, we didn't talk about it and we've run out of time mostly, but in the disability rights context as well. How can people be full equal citizens if they don't have access because of a disability? And she has that in her jurisprudence strongly as well.
Any quick concluding thoughts in the civil rights area, and then we'll hit on the lesbian gay rights case for extension real quick.
Okay, well, I'll just say one thing. I think picking up on your equal citizenship point, I think that is the question before us going forward. And whether it is the range of abortion bans or the many other restrictions that are like abortion bans but not called abortion bans, that's the question that's being teed up, and that framework I think is extraordinarily important. And I think we will see a connection between that and the range of cases, whether it be LGBTQ equality or beyond, that have sex stereotyping at their root.
Judge Pillard, I know that area of the law interests you too, the LGBTQ area. Do you see her jurisprudence translating and affecting that area as we see cases coming down the pike?
So one of the things that's interesting about her focus on individuals, I mean, in some ways it can be seen as a more conservative way of thinking about equality rather than thinking about groups and what groups need and how, women are differently situated or members of minority groups. But I think there's a real potential in her way of framing sex equality, and in particular of focusing on stereotypes and how assumptions about how people should behave according to their sex. That if you're a woman, here's the appropriate behavior, and how she's always tried to sort of question that and assure that people's opportunities are not restricted by that kind of generalization. I think this has a lot of upside, and you've seen some of this in some of the briefing in the cases asking the court to understand Title VII, the employment discrimination protection, as extending to discrimination based on sexual orientation or trans status. So if you are someone who was, born male or assigned a male sex at birth or gender at birth, and you go to work as a woman in your adult life, is it under that equal protection jurisprudence? Is that really akin to discrimination against a woman who shows up at VMI or a man who shows up at the nursing school and is being told, no, you're not behaving in the way that corresponds to what we, the society, or you as someone born into X sex, should be. So this is this is an idea that we're going to see pushed. And there are obviously different challenges, there are different issues that it raises, but it really, that whole idea about stereotyping as the target is something that has new fields.
Right, developed by her. Katie, your business is words. You have the last word.
Well, I think it's important to emphasize the democratic promise that lives in the rhetoric of Ginsburg's jurisprudence. There's an outward rhetorical posture as she situates the law within the world, within complexities of difference, within traditions of injustice. Her sustained practice of connecting legal argument to lived experience, her citation of non-legal voices as authorities, her calls for action outside of the court activate a dialogue between the judiciary and the broader public that invites a broader range of actors to claim agency in shaping the meaning of the law. We can see examples of this democratic promise in the various publics that moved into action in response to some of her recent dissenting opinions. And so while we celebrate her legacy and appreciate her individual accomplishments, in many ways, her rhetorical legacy points back to the people and reminds us that we have work to do too. We have a responsibility to build alliances, to speak up, to mobilize protests, to defend the Constitution. This might be the most important lesson in this particular moment for moving the work of gender equality forward.
Amen.
Okay, so right across, first let's thank our panelists. And you are all rewarded for your endurance. There's a reception across the green in the hotel building, and Justice Ginsburg loves to have her wine with everything, and there are treats over there, so please join in. Thank you again.
Thank you, gentlemen.